nowhere else.
Yeah. Oh, and it's already in there.
Well, Angie did it.
Okay.
Okay, did you all look at murder in the first degree, murder in the second degree, and then we got the child abuse dilemma?
As far as the child abuse dilemma and the felony murder, we've talked about it. We're fine with taking A out and
Okay.
just going with E. I don't think there's a reason to argue over that. So what I think it would say is to prove the crime of aggravated child abuse at the bottom of the page, number 1, Jonchuck Jr., E, and then the language of E. So I don't think we need letters A or E then.
Right, no.
And we were talking about taking out permanent disability, permanent disfigurement, so it just says great bodily harm.
Okay. Did you get that? All right.
Judge, that's under, we're under 1 for felony murder, first
Yes.
degree, number 1. We're taking out which letter?
A.
The bottom of the page.
And you still want willfully, child abuse means,
Yes.
okay, the intentional infliction of physical or mental injury upon a child, or do you want an or there?
Yes, and or where the brackets
And
are.
then, or active encouragement, that doesn't seem to be a
No,
problem.
I do think active encouragement comes out.
Okay,
All right.
And then we'd also talked on Friday about taking out the mental injury, and just doing physical injury in that definition.
okay, a physical injury,
Or an intentional act.
or an intentional act could reasonably be expected to result in physical,
Yes.
okay. Did you get that, Angie?
Yes.
So no mental injury. Okay, lesser included, murder second degree, manslaughter. Lesser murder second degree. All right, you want culpable negligence and manslaughter? I wouldn't think so.
No, Judge.
Okay,
So
You don't want to see-
manslaughter lesser is good the way it is. I assume that the lines mean that that's all coming out.
yes,
And no objection to the manslaughter instruction.
okay. There's the insanity instruction, which nothing was changed other than it's just the standard, the psychotropic medication instruction.
Judge, we have
There are-
objections to the insanity.
The one that was previously made,
No.
on the clear and convincing?
Under insanity on the first page, the give applicable, we object to both of those.
If definitively.
We discussed on Friday, I think. they
Yeah,
were-
we just, that's gone, yeah. What about,
Which one is gone? The first one, right?
yeah,
But
what about, oh, the second one?
Second one's gone
Insanity as a
too?
defense. Well, that goes, why are you objecting to that, the second option?
That's what we discussed Friday.
Although insanity is a defense. Well, I'm thinking that should stay in.
Yes. We do too, Judge. And we believe it says give if applicable and if requested, so we are not requesting it, and we do not believe it's applicable.
Why is it not applicable?
I don't believe we're trying to argue any diminished capacity or,
Right, but they're being told that they shouldn't use it in that way, basically. I'm gonna leave it in.
Judge, in the last paragraph of that insanity instruction, we object to the term necessarily.
That does not necessarily. What do you say to that?
Judge, that's a true statement. I don't understand that. I don't know what other word you could use.
Well, it is a true statement.
It's the law, so I'm not sure why we're,
It's a true statement.
I understand, I'm not suggesting it's not true, I'm suggesting that it's prejudicial to defense and we object to it. We're not asking it to be replaced, we're asking it to be removed.
You want the whole paragraph gone?
No, just the word necessarily.
all know that theoretically he could be released if he's NGRI. He wouldn't be, but legally he could be,
Right, and
so,
taking the word necessarily out does not change the truthfulness of the instruction. It more accurately reflects the state of the law.
well, if Mr. Jonchuck was charged with trespass, he probably would be released, so I'm gonna leave it in there.
Understood?
Okay. Everything else looks good to me. Right?
No further argument, Judge.
Mr. Bowman, Mr. Ellis, anything?
Looking through it, Judge.
Okay,
What, you mean as to everything or just to that instruction?
everything.
Oh, okay, then I have more objections.
Oh, okay.
Let's see. Well, we can jump to. Judge, on the rules for deliberation, number
Yeah.
7. Our problem with that is that's the second time the court's instructed him on that, so I don't think they should be instructed on that particular issue twice.
When did I instruct him on that?
Under weighing the evidence,
Oh,
not court officially, the instructions themselves.
where does it say that?
But if I
Oh, I see what you're saying. You may objection, or they want it out, I'd take it out if you agree.
Well, the only reason why they would want it out is if they want to, that I can think of, is that they would want to argue against it. I don't understand.
Well, no, it would be giving it to him twice. Weighing the evidence is under there, the paragraph, that's the last, and then it's rules for deliberation, it's there again.
Which would seem that the Supreme Court wanted that emphasized. I think we should leave it in there.
Yes, it would, all right, I'm not gonna do that. What other objection?
Judge, under weighing the evidence, the paragraph after 7.
You don't want that?
No, Judge. In other words, what it does is diminish the responsibility of the state. And
I don't think so. I think it highlights the responsibility of the state.
our point is that both sides have a burden. So this relieves the state of their burden, but it doesn't relieve us of ours. Or
No, I disagree. I think it's fine. Anything else?
No, Your Honor.
Okay.
Can we just go back
Sure.
to felony murder at the bottom of the first page? We're taking out the bottom where it says give if element 1A is alleged. And in the next page, what part of that top are we taking out?
Everything above willfully.
Everything above willful. Great. Okay.
You good?
Yep.
Okay. Is this draft sufficient for you, Mr. Bowman?
Yes, Your Honor.
Okay. So, is there anything else that we need to address at this time, other than juror number 1179 is unavailable and will be replaced by juror 2262. Ready to have him brought in?
Yes, Your Honor.
Okay. Defense, you ready?
Yes, sir.
Would it be okay if I set up the easel now, Your Honor?
Yeah, Johnson, Deputy Rice. 3 minutes.
when Mr. Boland's done, could we give them about 5 minutes just so we can set up?
Yes.
Judge, we renew all previous motions and objections.
Okay.
We do as well, Judge.
Very good, very busy, very good. I crammed a lot in. All right, all cell phones off, put away, very good. And those are your notepads, right? Very good.
Debbie Rice. Go ahead. Good morning, ladies and gentlemen. Good morning. Everybody set?
Yes.
Anybody received any information outside of court about this case?
No.
Okay. Both the state and the defendant have now rested their case. The lawyers now will present their final arguments. Please remember that what the lawyers say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding the case. Each side will have equal time, but the state's entitled to divide the time between an opening argument and a rebuttal argument after the defense has given its closing argument. Mr. Bowman?
Please, the court, counsel, members of the jury. It's been a long time we've been to get together, and we appreciate all of your time and attention throughout the course of this case. I want to start off in my arguments to you this morning with a statement that the defendant made the day of the murder. He said, "None of this will matter tomorrow." The day of the murder. So I want you to think about that for a moment. None of this will matter tomorrow. The man sitting right over here at the end of that table said that the day of the murder. In opening statements, you'll recall that I told you that what I wanted you to do during the course of this trial was to look deeper. You remember that I said that. It seems like a long time ago, and it was. But I said, look deeper. When you hear evidence, when you hear statements, the easy way out would be to say, well, because this sounded strange, because this sounded bizarre, because this statement was a little weird, therefore must be crazy, must be insane. That would be the easy way out. But I asked you to look deeper, and I believe you've done that. What I want to start off in the very beginning is talking to you about how we proved that the defendant, Jonchuck Jr., committed the murder. And then later on, we'll address sanity versus insanity. But first I want to go back to the very beginning of this case, which is what it's all about. It's why we're here. You remember that the very first witness who took that stand and sat in that chair was Officer William Vickers. His friends call him Drew. Officer Drew Vickers. He told you about how he was returning home after a long day and a long shift at the St. Petersburg Police Department on the evening of January 7th, 2015. He told you he had worked his shift, he was going home, and he saw a white PT Cruiser accelerate around him, driving erratically, going around 100 miles an hour. And he talked about how he's trained to estimate speed. The white PT Cruiser goes between him and another vehicle. He has to make evasive maneuvers, and then he doesn't initially pursue a traffic stop because the car is driving so erratically, he thinks it's probably a stolen vehicle. A few minutes later, as he goes around another curve, he sees and hears the defendant hitting the brakes or skid marks. He's concerned. And then, a few seconds after that, he sees the defendant stop the car on his own. That's important. Officer Vickers did not initiate that traffic stop. The defendant chose to stop on that bridge. Officer Vickers told you he would never conduct a traffic stop on the top of a bridge. That would be unsafe, it would be unwise. He wanted to do a traffic stop, if he did one, on the other side of the bridge. But the defendant chose to stop on the top of that bridge. He got out of that vehicle, looked at Officer Vickers, said, "You, Officer Vickers, you have no free will." You heard Dr. Burston tell you what that statement meant to him. He said that statement meant, "You have no free will, Officer Vickers, but I do. I'm going to do what I'm going to do." He walks between the vehicles, goes to the passenger side, takes out Phoebe Jonchuck, and in one motion drops her off the side of the Dick Meisner Bridge. A bridge that is 70 feet high. It's cold outside. It's in the low 40s, according to Officer Vickers. The wind is blowing at around 20 miles an hour. It's whipping underneath that bridge. You saw the photographs. The water's dark. And Phoebe Jonchuck is dead. We proved to you that the defendant, the man sitting right over here, is the one who did that. And we've proven that to you beyond any reasonable doubt. Officer Vickers told you that's the man who did it. He pointed to him. I said, "Are you 100% sure?" He said, "Absolutely." So there's no question. We've proven the defendant killed his daughter beyond any reasonable doubt. You even heard that Officer Vickers was shown a photo pack. Probably something rare for one police officer to do with another police officer. It's commonly used with civilians, but this is a homicide case in which Officer Vickers had actually become the witness. And he was shown a photo pack, and he identified the defendant, someone he had never seen before or met before. You heard that other officers immediately got the call that the defendant had thrown a child off the Dick Meisner Bridge, and they received word that it was a white PT Cruiser, and Officer Vickers had called out the tag, DERP 27. And within moments, officers are flying across the Sunshine Skyway looking for him. You heard that one officer said she was passed by a trooper and she was going 125. Another officer said he was going 137 to try and find this defendant. And they find him because of their efforts. They find him. And there he is, just moments later, in the white PT Cruiser with the same tag, DERP 27. And they all came and took that same witness stand, and they all pointed him out. Just like Officer Vickers said, "That's the man that threw the child off the bridge," they said, "That's the man in the white PT Cruiser." That's the man that we stopped. That's the man that we arrested. You heard that Phoebe's body was found 90 minutes after she was thrown off the Dick Meisner Bridge. The medical examiner came in and testified that that was otherwise a healthy child. There was nothing wrong with her except for what the defendant had done to her. The only cause of death for Phoebe Jonchuck was drowning and or a contributory cause of hypothermia. And you heard and saw photos of her blue lips that the medical examiner called cyanotic because of the cold. You saw photographs of the injuries to her legs, to her thighs. We learned that those injuries, like I told you in opening, were caused while she was still alive, which means she hit something on the way down as she plummeted 70 feet to the water. And we learned that there was petechia in her lungs, which Dr. Wilson described as small, pinpoint-like hemorrhages, evidence of asphyxiation, consistent with drowning, that there was a frothy liquid in her lungs, consistent with drowning. Again, all evidence that we have established and proven to you, members of the jury, that the defendant killed his daughter, Phoebe Jonchuck. She was otherwise healthy, happy, and alive until that moment when the defendant killed her on January 7th into the early morning minutes of January 8th, 2015. I want to talk to you about the law. The judge, in a little while, when we're finished with our closing arguments, is going to instruct you on the law. She's going to read what's called jury instructions. That is the law of this case. When you became jurors, I know it probably seems like it was a long time ago, you sat right there on day one, you stood up. Some of you may remember, you raised your right hand and you actually took an oath. And that oath was that you would follow the law. And the law that the judge reads to you is the law that you swore to uphold. And we're asking that you do that. And so I'm going to talk about some of these principles of the law. I told you in opening that the defendant is charged with first-degree murder. First-degree murder can be proved by one of two ways. The first is premeditated murder. The second is felony murder. And I talked about that in opening, and I want to spend a little bit of time with that on right now. When you look at the verdict form, which is the form that you will have to check off to determine what your verdict is and to tell us what your verdict is, you will see that the defendant is charged by the state of Florida with first-degree murder. And the verdict form will give a place to check first-degree murder. There are two theories by which we have proven to you first-degree murder. The first is premeditated, and as I said, the second is felony murder. Both premeditated murder and felony murder are both first-degree murder. So that's important that you remember that. When you make your decision and when you check off the verdict form, there won't be options for premeditated murder or felony murder. It will just say first-degree murder. So I want you to understand that both felony murder and premeditated murder are first-degree murder. Killing with premeditation is killing after consciously deciding to do so. The decision must be present in the mind at the time of the killing. The law does not fix the exact period of time that must pass between the formation of the premeditated intent to kill and the killing. The period of time must be long enough to allow reflection. That's a key word, reflection, by the defendant. The premeditated intent to kill must be formed before the killing. You'll see the law does not say that in order to have premeditated murder, the defendant had to form his premeditation a month before, or a week before, or even a day before, or even hours before. The law says that it has to be present in your mind at the time of the killing, and the period of time for reflection, for premeditation, must be long enough to allow reflection by the defendant. And you don't have to worry about copying this down, because you'll have that with you when you go back to deliberate. The judge will give you all these instructions.
Yeah, ladies and gentlemen, I always remember to tell you, sometimes too late. You'll have a copy of all the jury instructions, so you don't have to take notes about this.
So I would submit to you that the evidence shows that when the defendant chose on his own to stop on the top of the Dick Meisner Bridge, to get out of his vehicle, to walk between his vehicle and Officer Vickers' police cruiser, goes to the passenger side of the vehicle, opens the door, sees his child, unbuckles Phoebe from her booster seat, pulls her out, and then turns and drops her off the side of the bridge, that at that moment he has had enough time to reflect about what he's going to do. And under the law, if he reflected about it enough, according to this jury instruction, then he is guilty of premeditated murder. That's first-degree murder. And we've proven that to you. The other way we get to first-degree murder is felony murder. Mr. Ellis told you in jury selection a long time ago about the analogy, some of you may remember, of the person who commits arson, and they didn't intend for anyone to die, but there was a homeless person who'd crawled into the house to sleep that night, and in the commission of that arson, that homeless person died. And he gave that as an example of felony murder. In this case, we've also proven to you that the defendant is guilty of first-degree murder because he committed felony murder. The crime that the defendant committed in this case that he's guilty of, which makes this felony murder, is aggravated child abuse. Child abuse is defined as the intentional infliction of physical injury upon a child, or an intentional act, like dropping your child off a bridge 70 feet high above the water, that could reasonably be expected to result in a physical injury to a child. If you intentionally inflict physical injury upon a child, or if you commit an act that you know is reasonably expected to result in physical injury to a child, then that's child abuse. What makes this aggravated child abuse is if you commit this act and there's great bodily harm. We know that this was aggravated child abuse. If you take your child and you drop her from a height of 70 feet into the water below, then you've committed aggravated child abuse. He committed an act that caused great bodily harm. He knew what the result would be. Anybody would. That's aggravated child abuse. And in the course of that aggravated child abuse, Phoebe Jonchuck died. That's felony murder under the law of the state of Florida, and that is first-degree murder. Either way, we've proven first-degree murder. Premeditated or felony. So let's talk about insanity for a little bit. This is the law on insanity. Several of the experts have quoted this law. You've heard it from several of the lawyers. And let's talk about it. At issue in this case is whether Jonchuck was insane when the crime allegedly was committed. A person is considered to be insane when, number one, he had a mental infirmity, disease, or defect, and because of this condition, he did not know what he was doing or its consequences, or although he knew what he was doing and its consequences, he did not know it was wrong. We talked about two different prongs, prong one and prong two. Prong one, he has a mental infirmity, disease, or defect. But that's not enough. It doesn't stop there. I told you that in opening statement. Just because someone has problems, just because someone has a mental illness, does not make them insane. You have to have step 2. Because of that condition, the defendant, the man sitting right over here, either didn't know what he was doing, he didn't know he was killing his child, or he did know he was killing his child and he didn't know it was wrong. In order to find him insane, you would have to believe both 1 and 2. That he didn't know it was wrong. Members of the jury, there's a lot of talk about the defendant's life in this case. Some of the witnesses went back to 5 years old. What was he like as a child? Some of the witnesses spent hours talking about the last 4 years in a state hospital. Some of them talked about him at the jail. I would submit to you the only thing that matters is what this man was thinking on the top of that Dick Meisner Bridge on January 8, 2015. What was going through his mind in those moments on that bridge with Officer Vickers? That's all that matters. Did he know what he was doing with Phoebe Jonchuck, and did he know it was wrong? The answer is yes. He clearly knew what he was doing, and he clearly knew that it was wrong. The law tells you in determining the issue of insanity, you may consider the testimony of expert and non-expert witnesses. You heard from both. You heard from doctors. You heard from family members. You can consider both. You decide who's credible. You decide who's reliable. The question you must answer is not whether the defendant is insane today or has ever been insane, but whether instead he was insane at the time the crime allegedly was committed. That's what the law says. Was he insane on the bridge? Did he know what he was doing just after midnight on January 8, 2015? I would submit to you that the experts in this case, the defense experts, did not tell you what the defendant was thinking on the top of that bridge. Which one of those 3 defense experts, Dr. Otto, Dr. Mackless, or Dr. Mayer, told you what the defendant was thinking on the top of that bridge? None of them, because they can't. And even their explanations of why they think he did it are all different. And we'll talk about that some more. But Dr. Otto said the defendant knew that he was killing his child. He knew the consequences of his actions, but he didn't know it was wrong because he thought he was saving the world. Dr. Mayer, their third doctor that they called, couldn't tell you why he did it. The defendant told Dr. Mayer that he thought he was trying to save Phoebe and that he would toss her up and she would be like an angel and fly away. Completely different. Told Dr. Mackless that he was doing it because he had to save the world. He didn't jump. And then later on told him that he thought she may have been rescued by a school of dolphins. None of these experts can tell you, or did tell you, why he did it. And that's why this is important. All persons are presumed to be sane. The defendant is presumed to be sane. That's what the law says. The defendant has the burden of proving the defense of insanity by clear and convincing evidence. That is their burden to prove to you that he was insane. Clear and convincing evidence is evidence that is precise, explicit, lacking in confusion, and of such a weight that it produces a firm belief without hesitation about the matter in issue. I could go through all of the testimony, but I don't think I need to do that because you were here paying attention and taking notes. But I would ask you, when you consider the testimony that you heard from the defense experts in this case, and you question it, was it precise? Was it explicit? Or was it lacking in confusion? I would submit to you that if you answer no to these questions, it was not precise, not explicit, not lacking in confusion, but was confusing, and does not produce a firm belief without hesitation about the matter in issue, then you are not convinced by clear and convincing evidence that he was insane. Let's talk about what the defendant did right after he committed the murder. He fled. He got away. Evidence, strong evidence, that he knew he had done something wrong. Evidence of guilt. Evidence of wrongfulness. In order to be insane, the defendant would have to have a mental illness and then not know what he did or not know that it's wrong. The fact that he fled is evidence that he knew it was wrong. You can have mental illness. You cannot have mental illness. We could argue about that. Most of the experts said he had mental illness. But it doesn't matter if he knew what he did was wrong. He fled. You heard from our second witness, Mr. Willie Wynn, the toll booth operator. And what did he tell you? He was working the lane and he hears tires screeching. He's got several cars in his lane who were waiting to pay their tolls at the toll plaza just south of the Dick Meisner Bridge, and the defendant slams on his brakes and he doesn't stop and wait to pay the toll. He backs up, drives over cones into a closed lane so he can speed through the toll plaza to get away as fast as he can. That's evidence of fleeing. Why would he be fleeing? Because he knows that what he did was wrong. It's consciousness of guilt. And if he knows what he did was wrong, then he is not insane. And then he is guilty of first-degree murder based on the fact that we proved the murder. You heard that once the defendant crossed over the Skyway, he went to Interstate 75, and he has a choice. He can go north or he can go south. He told defense experts he was fleeing south because there was an ice age coming. Do you remember that? That was a delusion. But does he go south? No, he goes north. How many defense experts said you can be psychotic and you can still drive a car, you can go through a drive-thru, you can order a hamburger? If you can be psychotic and pay attention to street signs, why does he go north if he's fleeing the ice age? Then you heard Officer Sousa and Gillis, who caught up with him. Officer Sousa testified that when they were pursuing him, he was going as fast as 90 miles an hour. That is flight. That is getting away. Why is he going north? Because he's from Tampa. He's going back home to get away. And then Officer Sousa said before the defendant realized that Officer Sousa was behind him, he actually saw the defendant take an evasive maneuver around the semi. You'll recall that testimony. And the semi had to kind of get out of his way. Again, fast, trying to get away. And then when the defendant finally realizes that the police are behind him, he goes right into the right lane, takes a U-turn, and drives right back at Officer Gillis. Head on. She has to take an evasive maneuver. She testified to that, to avoid being struck in a head-on collision with him. When the defendant was asked by experts from both sides about the flight, the fleeing, some of the strongest evidence we have that he knew what he was doing, you'll recall that he conveniently doesn't remember the details of that. Dr. Otto was one of the defense doctors. He was the second doctor that they called of the three. And you'll recall that he said, this is complicated. He didn't say this is easy for him to give his opinion. And when confronted about it, he said that there is evidence of fleeing. There is evidence of fleeing. Dr. Mackless, the first doctor that they called, also agreed that there was evidence of fleeing. And when I questioned him about evidence that the defendant may have been going up to 90 miles an hour, he had to agree that if he's speeding, then that could be evidence that he's escaping. We showed you video of the defendant at the Manatee County Sheriff's Office. You watched that. And we felt the need to play the whole thing, and that it was important to play it. And what did we learn in the video at the Manatee County Sheriff's Office? The defendant said some odd things, for sure, but he was not psychotic. He was not psychotic. And at some point in that video, he said, "How's Phoebe?" Do you remember that? And what did Officer Huff say? Who's Phoebe? Defendant thinks for a while, says, "Phoebe Jonchuck. She was my daughter." He's talking about his daughter in the past tense because he knows that she's dead. He knows that he killed her. And he knows that what he did was wrong. The defendant is then sent to a state hospital. And you heard from the experts at the state hospital, and I'm sure you'll be hearing more about that this morning. But I also want to point out to you that the state hospital did 2 tests on the defendant. Only 2. One was a legal knowledge test, legal knowledge, and the other was a memory test. And the evidence was that neither test was to determine if he was psychotic or not. So I want you to think about that when you consider the evidence and the testimony from the state hospital. Dr. Mackless, who was the very first doctor that testified for the defense, said most of the evaluations that he does are for the defense. You can consider that as evidence and bias. Dr. Otto, the second doctor they called, agreed that he was 2 to 3 times more likely to be hired by the defense than the state. Again, evidence that you can consider when you consider their opinions. Dr. Mayer, the third doctor, also said, used to do a lot of defense work and still does. So that's all evidence that you can consider. All 3 doctors tried to paint a picture for you of the defendant as being severely mentally ill from childhood. But what was the actual evidence that you heard? You heard that when he was 5, he had behavior problems. He had ADD. Nowadays, everybody has ADD, or attention deficit disorder. When he was in his 20s, he goes and sees a psychiatrist, Dr. Arthur. And what did we learn that Dr. Arthur was treating him for? Mostly mood problems. There were some notes about paranoia. There were some, one note about a hallucination, which I'll come back to. But the medication, the treatment, the notes, all indicated a mood disorder. No one came in here and said that the defendant doesn't have any problems. And no one is disputing that he has problems. But Dr. Arthur was not treating the defendant for schizophrenia. He was treating him for a mood problem. He diagnosed him with bipolar 2, which is a mood disorder. And you heard that bipolar 2 will have a major depressive episode and can kind of be like manic depressive. Dr. Lazaro told you that Dr. Arthur, according to his notes, never drug tested the defendant. Not once. And we know the defendant was using drugs during that entire time period. So when we talk about the one hallucination that's in the defendant's records from Dr. Arthur, where he felt like his skin was bubbling, the one isolated hallucination, and only one, I want you to consider that all of the experts, even the defense experts, agree that that could have been drug-induced. That is not evidence that the defendant was psychotic. And in fact, on one of the documents that Dr. Arthur had in his records, that was a record for disability, he was actually asked, are there hallucinations, delusions, and he indicated none. I would submit to you that the defense doctors cherry-picked things that were good for them and left out things that were bad for their opinion. And you can consider that when you're considering whether their evidence is precise, explicit, and lacking in confusion. And I'll give you just one example. You'll recall that at some point in this case, you heard that the defendant had a friend named Melody Dishman. And at some point in their friendship, they were lifelong friends going back to childhood. At some point, the defendant told her, if I ever get in trouble, I will claim insanity. And then actually, during a deposition in the middle of trial, we learned that that statement was made when they were about 12 years old. So you can consider that for whatever you want to consider that for. If that has little weight to you, then that's perfectly fine. But what I would submit to you is when the defense doctors were told about that statement by Melody Dishman in the police reports, that the defendant had made that statement to her, the defense doctors all agreed that they disregarded that statement when they didn't even know that it was made. Let's think about that for a minute. In the same police report, Melody Dishman tells Detective Kenny Miller the defendant said if he ever gets in trouble, he will claim insanity. Within the same paragraphs, Melody Dishman also talks about how the defendant was texting.
Objection, facts not in evidence.
Ladies and gentlemen, you rely on your own recollection as to what you heard. Thank you. You may continue.
So you do rely on your own evidence. I think you'll recall that when I crossed Dr. Mackless, that I confronted him with the fact that these statements by Melody Dishman were all in the same police report to Detective Miller. Okay? But you rely on your evidence, your own memory about that. But when I confronted Dr. Mackless about that, it was clear that he took out the statements and relied on the statements where the defendant was saying things to Melody that sounded crazy or sounded weird, called her a demon. He relied on that. Dr. Otto relied on that. Dr. Mayer relied on that. But yet the statement, I will claim insanity if I ever get in trouble, they rejected that when they didn't even know when it was made. To them, that statement could have been made the day of the murder. They didn't look into it. They didn't seek clarification about it. They didn't inquire further, try and get in contact with Melody Dishman to ask when it was made.
Objection, improper.
Sustained.
Should we approach on that? The doctors could have followed up on that. They could have tried to inquire about when that statement was made, but they didn't. So my argument to you about that statement is it shows the bias of these doctors, their willingness to latch on to and cherry pick the statements that are good for them and reject statements that may be bad for them without even inquiring further about it. So you can consider that when you consider it's their burden. And is the evidence precise explicit, and lacking in confusion. You'll also recall that we asked 3 of the experts, could this have been a suicide by cop? And you'll remember that suicide by cop was explained, and most people probably know what that means anyway without any explanation, and that's someone who wants to take their own life and they want the police to do it for them. They're going to go threaten themselves, a police officer, or someone else in hopes that the officer will shoot them. That's a suicide by cop. 2 of the defense experts were asked, could this have been a suicide by cop? The defendant was threatening a child. Now, Officer Vickers didn't have time to respond like that because he wasn't even expecting a child. He was expecting a gunfight. But they were asked, is that a possible scenario? And 2 of the 3 said, yes, it's possible. Well, if it's possible that it's a suicide by cop, think about that for a minute. The very nature of suicide by cop is that you know what you're doing is wrong and you want the officer to hurt you. So if 2 of the 3 experts say it's possible that this could have been a suicide by cop, then they're essentially saying it's possible he could have been sane. Is that evidence that is lacking in confusion? Does that evidence produce a firm belief without hesitation about the matter and issue that he's insane? It does not. We heard a lot about delusions in this case too, right? And every single expert was asked to define the term delusion. And how did each expert define it? The very first word that they all used to define delusion is fixed. Do you remember that? They said a delusion is a fixed, false belief. Now, there's a difference between hallucinations, which is hearing voices, and delusions, which is a belief that you have as a psychotic individual that no one can change. Fixed, false belief. Dr. Mackless, a defense expert, defined it as, well, you believe that the FBI is coming after you, or you believe the CIA is spying on you. It's a fixed belief, it's a false belief, and he even told you that nothing you say to that person who has that delusion will change their mind. You could talk to them till you're blue in the face and say the FBI is not really coming after you, and they're still going to believe it. It's a fixed, false belief. Dr. Mayer, the 3rd doctor, tried to massage that term a little bit, and he said, well, it's fixed, but fixed is a relative term. But let's talk about this, because this is important. Dr. Lazaro and Dr. Burstyn gave you examples of delusions. They said that delusions with psychotic people are so strong, right, that people will gouge out their eyes to follow the delusion. Dr. Lazaro gave an example of someone who cut off his penis to follow a delusion. They will do whatever it takes to follow that delusion, that it's a fixed belief. And Dr. Lazaro explained how delusions work. She said that there's always going to be depth to the delusions. They're not just going to be superficial. If someone believes that they are God, then they're going to talk about how they're God and this and that. If someone believes that they're the Pope, they're going to talk about how they're the Pope, and they will stay with that delusion. She explained to you the delusion doesn't go from God to the devil to the Pope, back to the devil. And the defense may, in their closing, talk to you about Dr. Lazaro, and they may dispute some of the things that she said. But I want you to remember this. In January of 2019, their law firm hired her, used her, and she testified for them.
Objection. That's not evidence.
Ladies and gentlemen, again, you need to rely on your own recollection.
It was clear in her testimony that she said in January 2019 she testified for them. Even Dr. Otto, when talking about the priest, Father William Swingros, and the defendant's conversation with the priest, was confronted with the fact that the defendant said, I'm the Pope. The priest, Father William Swingros, said, no, you're not. And the defendant said, yeah, you're right, I'm not. You remember that? said he's the Pope, then he takes it back. Dr. Otto, their own expert, said delusions don't work like that. Their own expert said that. That's not how delusions work. So let's talk about the delusion. Because the defense has told you that the reason why the defendant killed Phoebe Jonchuck is because the defendant was psychotic, even though he's never been psychotic like this before in his life. He was psychotic and he had a delusion that both he and Phoebe needed to die or the world would go to hell. Everyone would die. That's the delusion that he had, according to the defense. Dr. Mackler said both needed to die to save the world. There was an ice age coming. And then Dr. Mackler said he changed again right before and said, he's God, or thought that he's God. So the delusion completely switches from demons and the whole world's going to hell to I'm God, right before he does it. Delusions don't work like that. Dr. Otto, both the defendant and Phoebe have to die to save the world. There's an ice age coming. And you recall Dr. Otto even said the defendant knew he had killed her. Again, precise, explicit, lacking in confusion? No. So both these doctors say that's the delusion. They want you to believe that this delusion was so strong, so powerful, that he killed his child because he really believed that if he didn't, the world would come to an end and everyone would go to hell. That's what they're saying. That's what they're telling you. And that's their burden. But if the delusion is that both he and Phoebe both have to die to save the world, he didn't follow the delusion. Because last time I checked, he's still alive. He's sitting right over there in the purple shirt. He didn't die. He didn't jump. So if the delusion is that he has to die and Phoebe have to die, and that's why he killed Phoebe, why didn't he jump? If the delusion is that strong and that powerful, then you follow the delusion. That's what they're saying. But he didn't follow it because there was no delusion. There was no delusion. He's still here. He didn't jump. He didn't follow the delusion. If the delusion was that strong that he would kill his daughter over it, then he would have jumped too. Because they told you the delusion was they both had to die to save the world. And then Dr. Mayer says the defendant told him that he tossed Phoebe up because it was like she was an angel and she would fly away. A completely different delusion that makes no sense. Delusions don't work like that. Their own expert said so. They don't work like that. You heard from our first state expert, Dr. Burston. Dr. Burston told you that he does work for the state and the defense. He said it's about 50-50, state and defense. Very balanced. And what did he tell you? He explained about how in early development people can obtain what's called attachment disorders. He reviewed the history of this defendant. He interviewed witnesses. He interviewed the defendant's mother. He interviewed the defendant's father, other collateral witnesses. And what did he tell you? That if you don't have early bonding in the very beginning, that can lead to attachment problems. And he went through that. And he talked about how if you have those problems, they can develop into something called personality disorders. And you'll recall Dr. Otto, the second doctor that they called, also agreed that the defendant had personality issues as well. He said he found features of antisocial personality disorder and borderline personality disorder. The same issues that Dr. Burston said that the defendant had. And that was the defense doctor. And what were these issues about? They were focused on the defendant's upbringing with his mother, the fact that she wasn't there for him. There wasn't that early attachment. And Dr. Burston explained how that will lead to problems. problems that will grow, problems that will fester. And what was going on at the time of the murder? The defendant was angry and he was jealous with his mother. And I talked to you about that in opening statement. His mother, that was never there for him his entire childhood, who was involved in drugs and went to jail, has finally got her act together. And she's giving all of this love and attention to Phoebe. She didn't care about him. But now all of a sudden she cares about Phoebe? And he's jealous. And he's angry. And he's resentful about the attention that she is giving this child that he never got. The mother came and testified. She talked about it. Other witnesses interviewed her. And you recall that when the defendant was interviewed at the Manatee County Sheriff's Office, he was asked, when did this all begin? And you can watch that video again. It's at the end of the video. And he tells Detective Miller, it all started around Thanksgiving at Denny's. Well, what started at Thanksgiving at Denny's? It was seeing Michelle Kerr, Phoebe's mother, with a new boyfriend. It was then the Christmas dinner when they got together and he saw that Michelle Kerr not only has a new boyfriend, but now has transportation. He told Dr. Burston about how this was a real threat because she could come get Phoebe anytime they wanted to. You learned about how the defendant would use Phoebe. He would go from house to house to house, and that would be his way to get in the door. And now all of a sudden, Michelle Kerr, Phoebe's mother, has the ability to come and get Phoebe. They have a house now. She couldn't drive before because she has MS, but she has this boyfriend. And they went to the house for Christmas. And that becomes a very real threat to him. So much so that he seeks out a family law attorney. And the family law attorney tells him, Michelle Kerr can come get Phoebe with the sheriff anytime she wants, and there's nothing you can do about it. He knew that. This was a real threat and a real problem. And over New Year's Eve, things flare up. Text messages are exchanged. Threats back and forth. He sees Genevieve Torres and begins emailing her, frantic, to get that appointment with her around New Year's. He's angry at Michelle, Phoebe's mother. There's words exchanged between the two of them. He's angry with his own mother in the way that she adores Phoebe, unlike she ever cared for him. And on January 5th, just a couple days before the murder, he goes and grabs Phoebe, takes her away from his own mother, who was taking care of her in the middle of the night, and says he's going to do something to ruin the rest of her life. What else could ruin the rest of her life other than hurting the only person that she was living for at that time? She told you that Phoebe was the light of her life, the reason why she got her act together. And on the night that this happened, he reports that he had a fight with his father. His father goes to call the police. He unplugs the phone because he doesn't want to get in trouble because he knows he's on probation. A reality testing, a reality check. The defendant knows legal consequences. Mental illness or not, you can debate about that all day long. He knows right from wrong the night of the murder. He's got to leave his dad's house because he had a fight with his dad. At some point he calls his mother and wants to come over there. Reality testing again. They had made a plan for the night. He was going to take Phoebe to school the next morning, the morning that he killed her. And he was going to go to work, where he worked at a Jamaican restaurant. And his mom was going to make dinner that night. Mom tells him on the phone, no, let's keep to the plan. Does that sound psychotic to you that he made that plan? I would submit no. Mom and Dad reported, John is John. John was always saying weird things. John was saying things to mess with people. but reality testing. There was reality testing that night. When the mom says, no, you can't come over, which she regrets to this day, the defendant leaves, and he's got no place to go. In his mind, he's being rejected by his mother that he's come to hate. There's a threat that someone is going to take Phoebe from him, a very real threat. The Social Security office is sending letters asking where's the money. He's angry. And what does he do? He goes to his friend Noemi's house, someone that he'd stayed with once before. And he's frantically texting her. You heard from Tara Velez, the neighbor, who said she was in her car drinking Starbucks with her friend. She called the police after this had all happened. But when she's in the car drinking her Starbucks, she said it looked like he had 1,000 things on his mind. And he did. He's trying to get in with Noemi. He's trying to find another place to stay, someone else to stay with. And he's texting her. Some of those texts were romantic. Wants to be with her. And what does she do? She won't even come to the door. That is the final rejection. That is the end. At this point, he's in a rage. He's angry. When people are angry and when people are in a rage, they do horrific things that may look and sound crazy, but that doesn't make it insane. Dr. Burson said these issues were not delusions. They were real, money, shelter, relationships, very real issues. Dr. Burson described the whole scenario with this defendant like a teapot. You turn on the heat and it starts to simmer. And then it starts to percolate. And the next thing you know, the teapot is screaming. That's what happened with Jonchuck. The evening of January 7th, 2015, the kettle is screaming. He's angry and he's in a rage. Dr. Burson said that in that type of conflict, you can either be driven by psychosis or your personality. And in his opinion, the defendant's actions that night on that bridge were not driven by psychosis. They were driven by his personality disorder. The defendant said, you have no free will to the officer. He said, I'm going to do what I'm going to do. A lot of people might say, how could you ever do that in front of a police officer? But when you are that angry, when you are in that much of a rage, he didn't care. He didn't care if it was a cop or not a cop. He was going to do what he was going to do. He was going to do the one act that could hurt as many people in his life as possible. The people who had rejected him. The mother of Phoebe and his own mother. In one act. It was not a psychotic act because the supposed delusion wasn't followed. It was anger, unbridled anger. It was rage that drove him to do it on the top of that bridge. And if he's not insane, they have not proven it to you, then we go back to, did he commit the murder? And the answer is yes. How did we prove the murder? Officer Vickers told you the defendant did. Members of the jury, there's only one verdict that is supported by the law, the evidence, and your own common sense. That is a verdict of guilty of first-degree murder. I'm asking that you deliberate, you consider the evidence, and you return the only lawful verdict. And that is guilty of first-degree murder. Thank you.
Thank you, Mr. Bowling. Ladies and gentlemen, we're going to take about a 10-minute break for the defense to set up some exhibits for their closing, so we'll reconvene at 12:15. Thank you. We'll just pass on.
All right, folks. recess till 12:15 according to the courtroom clock.